Well, good morning, everyone. This is George Spees at the Pennsylvania Office of Open Records. Welcome to this morning's webinar. I hope everyone's doing okay. This morning, we're going to talk about the right to know law and the payment side of that law and how it impacts both your perspective as a requester and for the agency. A couple preliminaries that I'd like to get out of the way here before we jump into the presentation itself. First, the PowerPoint that we use for this presentation, as well as all of the PowerPoints that we use, are on our website. Go to the training page, there's a drop down, and just click on the page that has the PowerPoints on it. Scroll down, find the one that you need, and feel free to download it and use it for your own reference, or if you're doing any localized training, you're more than welcome to use the PowerPoint for that as well. These sessions are being recorded. And if, for instance, if you have a colleague who wasn't able to join us this morning but is interested in the topic, you can send in a flash drive with a note indicating what recording you want, which session you want, and include then a self-addressed stamped envelope. And turnaround's usually about a week, and we'll make more than happy to make a recording for you and mail it back to you. Because of the file size, the recording files are so large, we can't email them to you, and it's just unwieldy to try and get them up on the website. So send us a flash drive. That seems to have been working out here for the last year, and we'll get that to you lickety-split. If you have questions during the session today, feel free to type them into the meeting chat feature, and I'll do my best to answer them as we're going through the presentation. Two things. First, we're talking about the right to know law and payment issues, so try to keep your questions on topic, about that subject. Also, the shorter you can keep your questions, the better. Sometimes folks get on here and they type out a couple paragraphs or, what seems to be a couple pages. And it's just awkward for me to sit here and have to read through that. If it looks like, you're dealing with a situation that is unusually complex or unique to your particular situation, we'll do one of two things. We'll either wait until the end of the presentation and I'll come back to it, and we can talk about it online here for the good of the order, or we'll take the conversation offline. The contact information is on the screen right now, the phone number for our office, as well as the URL for our website, which you go there and you'll find email accounts that you can use to contact us with your questions. Usually they get routed to me, and I'll reach out to you either through an email conversation or a phone call, and we'll try and get you steered in the right direction. Okay, so I think that takes care of the preliminary stuff. Let's go ahead and take a look at the presentation itself. As soon as I can find my cursor, there it goes. Okay. The right to know law, section 1307, includes language about establishing a fee schedule. It gives that authority to the Office of Open Records. And we post it on our website. I think if you go to the first tab, right to know law, open that up and you'll see a reference to the fee schedule. That fee schedule does get reviewed every 2 years. Last time was last January. So we're into this, a little over a year. And we do solicit public comment, and we also reach out to heavy users and agencies to get their suggestions on how they believe the fee schedule can be amended. Last time around, as I recall, there were some fees that we raised. There were also some fees that we lowered. So, we do take your comment into consideration. Next time we do it, I'd encourage you to participate. If you have concerns, if you have some suggestions, please feel free to reach out. Essentially, when you look at that fee schedule, it's for hard copies, it's up to 25 cents a page, single-sided black and white, 8.5 by 11 or 8.5 by 14. The asterisk there, this is something that was added last time, is that if the response is so large that it exceeds 1,000 pages, Then anything above 1,000 pages, the fee drops to 20 cents a page. Okay, and then if it's color, we go up to 50 cents a page, single-sided, 8.5 by 11, 8.5 by 14. And then all other sizes would be actual costs. There, I'm referring to something like a blueprint. Okay, if you have to make a blueprint and you don't have a large-scale copier, you have to run down to Staples, Kinko's, or the local architectural firm. Whatever they charge you, you can in turn pass that cost onto the requester. Now, down at the bottom in red, I have read the footnotes, and here I'm referring to the fee schedule. With the fee schedule, you're going to find various points, and then you go down to the bottom, and that's where I think the meat of the fee schedule really is. If you want to understand how the fee schedule works, be sure to read the footnotes because it explains a lot of those unique situations that you might encounter. In many instances, the footnotes are there as the result of language in final determinations or court decisions related to disputes over fees and how they apply relative to the right to know law. So, get out your reading glasses, get out your magnifying glasses, and read that fine print with the footnotes, and that will help you understand how the fees are appropriately charged. Okay, we mentioned pass-through costs. These are actual costs that can be documented when an agency is preparing a response. Some typical examples with pass-through costs would be postage. Let's say the scenario is someone has submitted a right to know request and they want hard copy responses. Okay, so they make or the agency makes the copies. They're going to charge, the up to 25 cents a page, and the requester wants them mailed to them. Let's say, maybe they're out of state. Well, you can take all those copies, put them on your postage meter. It's determined it's going to cost, let's just say $3.15 to mail them. Well, you can add that $3.15 to your invoice to the requester because that's an actual documented cost, okay, the $3.15. Sometimes, like I mentioned earlier, outside copying fees for blueprints, that would be an appropriate pass-through costs. Here's one that we don't encounter that much anymore, but it still comes up every once in a blue moon, is analog recordings. Here, we're talking about cassette tapes. Usually the scenario is that an agency will have a public meeting, and for purposes of keeping minutes, the secretary will record that meeting. And there are some that are still using the cassette tapes or the micro cassette tapes as opposed to a digital recorder or a laptop or even a cell phone nowadays. Well, someone submits a right to know request for a copy of the recording. The only way you can produce that is, you have to make another cassette or another micro cassette. The problem is that those double cassette decks that we used to have 30 years ago don't exist anymore. You can't buy them. And, if you still have one, it should probably be in a museum somewhere. So you have to go out, usually to like an audio store, that specializes in stuff like that. Sometimes a recording studio may have them. And whatever they charge the agency for making a copy of that cassette, again, that can be passed on to the requester. Now, I'm going to have to backpedal on that a little bit because that's the way it used to be. However, there was recently, meaning a couple months back, a decision where the agency attempted to pass on labor costs that it was being charged to produce copies to the requester. And the court concluded that based on language in the right to know law, that because you cannot charge for labor, that includes labor that may be charged by a third party. So we're kind of in a state of flux here. This is an area where, the right to know law and the case law is evolving. So we want to caution you. And when I say that, this is a valid pass-through cost, that may not truly be the case because of this emerging case law. It's something we're monitoring to see whether it, picks up any steam and how it will apply on a case-by-case basis. So I don't want to paint with a very broad brush when I say that you can charge for outside labor, because there's at least one court that's saying we have a problem with that. Okay, and then the other thing you can charge for is storage media. Obviously this isn't labor, it's a device. And the most common would be a flash drive. If someone requests a large amount of digital files, they're so large that they cannot be emailed, or the person doesn't want them emailed, then if the agency needs to use one of its own flash drives, you can charge for the price of that flash drive. But I also have another slide here where I want to talk about what might be a more, just a better system for you to use. Okay, but if you're giving files out using flash drives, you can add the cost of the flash drive onto any invoice that you might be sending to the requester. Okay, flash drives. Let's talk about this real quick. Now, I want to emphasize this is not a requirement. Rather, it is what has been identified as a best practice for dealing with requesters who are seeking a large amount of digital media. Perhaps it is a recording, and it's something that we do here at the Office of Open Records. It seems to work out for us well. When someone is requesting a large amount of electronic files and they want them on a flash drive, or maybe a flash drive is the best way to transfer those files. What we suggest, actually, this came about through pre-COVID training that I would conduct across the state. I was on the road a lot. A couple municipalities were saying, hey, this is what we do, and it seems to be working out. So we started adopting it here. So, I don't want to take personal credit for this. There are municipalities that were doing this before we adopted it here at the OOR. But anyway, what happens is that, number one, because of the size of the files, and it's just inconvenient to have to invoice for flash drives all the time and, to give them out. The other thing is that there are security concerns over someone sending us a flash drive that has already been used, that's already been opened. So what we do is, when we do have a large amount of digital media that has been requested, for instance, the recordings of these webinars are a good example. We ask that you send us an unopened flash drive. That way, there are minimal concerns about malware or viruses infecting our network. What some of these municipalities are also doing is they take the files and put them on a laptop, and then they disconnect the laptop from their network. It's freestanding. And then once it's disconnected, then they will put the flash drive in the laptop and transfer the files. That way, if there is any virus or malware, the software on the laptop picks it up before there's any fear of it getting into the network. And then they simply transfer the files, undock the flash drive, and mail it back. And what we do is say, send us a flash drive, send us a stamped self-addressed envelope. Well, you heard my spiel at the beginning, and that seems to work out. Okay, it's not a requirement. It's just a suggestion, a best practice that we found for dealing with a large amount of electronic files. Okay, moving on. Things you can't charge under the right to know law. Like I said earlier, you cannot charge for employee labor. That's simply considered the cost of doing business under, for government under the right to know law. And that includes an hourly fee for your employees, as well as any sort of fixed fee. It's surprising, but with our new executive director, she's very concerned about websites used by local agencies. So we've started this program where we go out and look at agency websites, and it is still surprising the amount of times we run across an agency that is attempting to charge a fixed fee for right-to-know responses. And that simply is not consistent with the right-to-know law. And we have to tell them that, you know, you need to stop this. You need to fix your website. You need to stop this practice. You cannot charge for any sort of legal review, whether it be by your in-house solicitor or some form of outside counsel. Again, it's simply considered the cost of doing business for government. You cannot assess, you know, a right-to-know processing fee or a redaction fee. This is another thing that, you know, we found on a couple websites where, you know, if our response to your right-to-know request requires us to redact anything from the records, we're just going to add on a $10 fee. No, you cannot do that. There may be instances where you are allowed to charge for redaction, but I'll explain that, and it is not a fixed fee in any way. Scanning fees. This doesn't come up as often as it used to, but we still get inquiries from agencies who are saying, look, I have to scan these hard copy records in order to email them to this requester. I'm going through the same exercise, and it's the same wear and tear on our copier that I would have if I were making copies. Why can't I charge for scanning? No. And it comes down to you're basically generating electronic records, and you cannot charge for electronic records. And there's a very good chance that you don't have to go through the exercise of scanning in the first place. And we'll talk about that here in a subsequent slide. No, you cannot charge for electricity. I don't know why I even have to put this on the slide, but twice in my career, I've gotten in the middle of arguments where, you know, that pretty much sums it up. An argument between a requester and an agency, and they said, well, we're going to charge you for the electricity. And my first response is, how? You know, how are you going to calculate that? But anyway, and then electronic records. Like I said earlier, you cannot charge for electronic records such as emails, Word documents, Excel spreadsheets, various database files. If they are already in electronic medium, that's an electronic file, and you cannot charge for that. Now, if there is a dispute over what the agency is charging and the requester, you know, takes exception to those fees, they can file an appeal with our office, and that is a valid reason for filing an appeal. As a matter of fact, if you go to our website, go under the Appeals tab, go down to the Docket Search tool, which gives you access to every decision we've rendered since 2010. It's, you know, 30,000 plus and counting. And simply type in the word fees in the random text string, and decisions will come up where you can go through and see how we have ruled when there's been a dispute over fees. And like I said, that's resulted in a lot of those footnotes on our fee schedule where we attempt to explain in a little greater detail what these fees actually entail. Excuse me, coffee there. Okay. This is kind of what I was referring to. This is a very important section when it comes to the fees that can be charged by an agency, because it's quite often misunderstood, or agencies simply don't realize that this provision exists. It's section 701, where it talks about the medium. And this is the request section of the right to know law. And I'm paraphrasing here, but it basically says that the record shall be provided in the medium in which it exists. When I use this term medium, we're talking about hard copy versus electronic. Okay, so if someone submits a right to know request, let's say it's by email, and they ask for the records to be sent to them electronically. And let's say that they are asking for copies of building permits. But then we go to the township or the borough, and it turns out that their building permit application and approval process is all paper driven. There's no electronic records kept or generated in any way. So the approved building permits are kept in a file folder in a file cabinet. Well, because they exist in hard copy medium, the request can be denied because the requester is seeking them in electronic medium. You see how that works? And the appropriate response would be, we have the records, but they're hard copy. We're more than happy to generate hard copy for you, but then they're going to cost up to 25 cents a page, single-sided, like I said. Now, the agency can, at its discretion, scan the hard copy records in, but that's converting them from hard copy medium to electronic, which you don't have to do. And if you do it, you cannot charge for electronic records. Okay, that's why you cannot charge for scanning. You may not have to scan, but if you do, you cannot charge for the electronic records that you're generating. Then we get into the issue of medium versus format, okay? And this is something different. Here we're talking about purely electronic records for our purposes. Actually not. This could apply to hard copy, but it comes down to someone requesting Excel spreadsheets. Now, it used to be with case law that if someone requested a spreadsheet, the agency could, at its discretion, produce a PDF copy, whether it be hard copy or electronic. It didn't matter. They could produce a PDF copy, and that was acceptable because the court said, look, under the right to know law, the agency is obligated to provide a copy. PDF, if you're familiar with it at all, is basically what I would call a snapshot of the Excel spreadsheet that does not include any of the functionality that the original spreadsheet has. For instance, you can't move your cursor to a cell, click on it, and see the formula behind that cell. Okay, the court said that's okay because you're providing a copy. In recent years, that has evolved, that's changed. Where we're at now is that if someone says, I want a copy of the Excel spreadsheet, then you provide the Excel spreadsheet, not PDF. But if they simply say, I want a copy of the spreadsheet, then PDF is acceptable. The fear from agencies is that, well, if we give them the spreadsheet with the full functionality, they'll be able to alter it and misrepresent what we're giving them. Okay, now that's an issue that would fall outside of the right to know law, but the reality is, I think I'm not aware of that ever happening. Okay, no agency has ever called back and said they've altered the spreadsheet, they've misused it, they're misrepresenting what we're doing. What can we do? No one has ever, to my knowledge, no one has ever had that actually happen. So I think it is an unfounded fear in simply giving them a copy of the spreadsheet in Excel is acceptable. And really nothing you need to worry about. Occasionally, we will run across proprietary formats. This is where an agency has gone out and purchased software that has been heavily customized, and it cannot generate hard copy, nor can it generate reports or output in a readily readable format, such as CSV or an ASCII text file or anything that a typical requester or user would be able to read. I've encountered this once with a school district, twice with police departments, where the police department was unable to generate an incident report in a format that the requester could actually read. So in those instances, the agency can deny the request because of the proprietary software and claim that the record doesn't exist in a readable format. and that's been acceptable. Haven't encountered that a lot, but it has happened. All right, redaction costs. Like I said earlier, an agency cannot charge a set fee for redaction. However, there are instances where you can charge for basically the paper that may be necessary in order to effect a redaction. Let me run you through this. Let's assume that everything that we're talking about is electronic. Maybe it's emails. So someone submits a right to know request for copies of these emails, and they want them sent to them electronically, obviously. Convenient, and it's free. However, the agency has determined that the emails are in fact public, but there are sensitive pieces of data that they need to redact on those emails. And they don't have any electronic software that allows them to effect those redactions. It could be social security numbers, it could be home phone numbers, it could be personal email addresses, information about minors, et cetera, okay? Clearly stuff that the right to know law allows you to withhold, but otherwise the content of the record is public. So in order to effect the redaction, they need to do it manually. So they print out the email, then take their Sharpie or whiteout or whatever, black out the sensitive piece of data, and then scan the record back in. Okay, if they've had to do that through a manual exercise, the agency can now charge for the piece of paper that it had to generate in order to effect the redaction of the otherwise electronic record. Okay. If you do have electronic redaction software, like for instance, Adobe, the Adobe Redaction Suite or the Adobe Office Suite that includes the redaction software, you know, the FBI has determined that it is secure. So you should use it. We're not saying you must use it, but you know, it's number one, it's easier. Number two, it results in not having to invoice the requester at all. Okay, but it's not part of the law. There's no case law that says you must use the redaction software. We're simply saying, look, you got it, you should be using it. This could also have an impact on inspections. You know, under the right to know law, you can request copies or you can request to inspect the records. Well, if you've got an inspection request, again, you know, if there are sensitive elements on what are otherwise public records, you can make redacted copies and then in turn charge for those redactions. Now, in any of these scenarios, I strongly recommend that before you incur any costs, that you reach out to the requester and let them know that, hey, there's probably going to be some de minimis costs here, because you don't want to catch the requester by surprise. All right, surprises are bad. Okay, it results in misunderstandings, and you know, if they think it's going to be free but it's not going to be free, things are going to go south. So communication is good. Reach out to the requester, let them know that you're anticipating there's going to be costs. That way everyone's on the same page when it does come time to generate that invoice. However, you know, with the inspection scenario, if you're making redacted copies for them to inspect and charging them for it, then they should expect to walk out with those copies because, you know, they're paying for them. So it's their property as far as we're concerned. Okay, let's talk about charging fees. And there's a point here that I really want to emphasize. In the other training, you know, I usually make a big point about how there are these deadlines in the right to know law that because of legal requirements on us and because of the way the law is written, that there's no wiggle room with these deadlines. that you have to provide an initial response within 5 business days, that you have the option of the 30 calendar day extension, and then you get into appeals, so forth and so on. All of the deadlines that are referred to during the request phase of the right to know process refer to the provision of a response. It does not refer to when you actually provide the records. Don't believe me? Read the law, okay? Download it from our site, take a look at it, look at the deadlines with each section. The agency shall provide a response within 5 business days, not provide the records, okay? So that can have an impact, obviously, on how you go about assessing fees and collecting those fees and providing the records, okay? When you think about the difference here, and again, well, I guess I'm not surprised because of the turnover with agency open records officers. They're still learning the system, and it's real easy to just assume something when you hear it from someone else. And the way the brain works, maybe you don't, maybe it doesn't click completely, and people think, okay, I got to provide the records in 5 days. That's not what the law says. The law says provide the response within 5 days. Okay, so how does this affect the whole invoicing process and so forth? Let's run through a couple scenarios here. First offhand, it says that all applicable fees shall be paid in order to receive access to the record requested. Translate that to English, it means that records are provided upon payment. The agency can require payment first, then provide the records. And you can wait for that, let's say the person sends in a check, you can wait for the check to clear. Okay, as long as the typical scenario would be you receive a right to know request. Let's run through the mental process here. First offhand, I'm going to do an estimate as an agency open records officer. And if it looks like the response is going to exceed $100, the right to know law allows me to say, give me a check for the estimated total amount because it's going to exceed $100. All right, so send me a check, and everything kind of goes on hold until that check is received. I like to refer to it as a security deposit. So the right to know law makes sure that if you get a big request that requires a big response, that before you begin committing your time and resources to producing the response, you're going to get that security deposit. Okay. And the next thing you need to do is grant the request within the prescribed deadlines. So you receive the request, you do that estimate, and by saying it's going to exceed $100, you're basically granting it for the most part. You're saying we're going to give you the record you're asking for, but by the way, it's going to exceed $100. If it's less than $100, then you cannot ask for the money up front. Okay, it's only if it exceeds $100. But I would still recommend reach out to the requester to let them know we think the response is going to cost $30. Are you okay with that? Okay, and if they say yes, then you proceed. If they say no, then you consider the request withdrawn. Hopefully you try and get that in writing, but for all intents and purposes, it would be withdrawn. Okay, so you begin processing your request or the response. And since you've within the 5 business days, you generate your approval, your grant letter. So you send that off and you say, we're granting your request. And by the way, it's going to cost $30. Send us a check. And when your check clears, then we'll provide you with the copies. Okay, completely acceptable because the response, your initial response has been produced within the 5 business days. Or, if you needed to take the extension by the end of the 30th calendar day, that's acceptable. Okay, you haven't provided the records within the deadlines. You've provided the approval, the grant letter, and said, send us the money. Okay, so that's the thought process as to how all this works. So then you process the payment, the check clears, the bank lets you know he's good for it, okay? Then you can arrange provision for the responsive records, meaning come down to the office and, pick them up, or, we'll mail them to you, or however, it all is going to work. Okay. So that's kind of the thought process I go through in explaining how you distinguish between when you provide the response and when you provide the actual records, and how you work out invoicing a requester. All right, now the whole invoicing process there's really nothing in the right to know law that covers how you go about doing this. Rather, it gives the agencies a great degree of discretion. You can take it on trust. You can say, here's the record, send us a check if you want to do that. Completely acceptable. The right to know law gives you that discretion. But where it doesn't give you discretion is in providing the responses within the prescribed deadlines. Okay, that you have to meet. If you don't meet it, as you've discovered, through our regular training on the right to know law and the basics course, if you don't meet the deadline, yeah, that is problematic for you. Okay. There's also a scenario I want to talk about. It's called record discard, which is described in section 905. Here, the scenario is that person has submitted a request. The agency has granted the request. And through discussions between the parties, they've arrived at an arrangement where the person is going to come down to the office to pick up the records, and they'll pay for them then. Okay, a fairly common scenario. Well, under the right to know law in this section 905, the agency is required to keep those records for 60 days, 60 calendar days, 2 months. All right, and if the person doesn't come to pick them up after 2 months, the agency can discard the records. They can throw them out, shred them, recycle, whatever it is they do. Now, let's assume then that on the 61st day, after the records have been destroyed, the person does show up. Well, there's several dynamics that come into play here. First offhand, let me go back to that $30 figure, just for a hypothetical conversation. The person still owes that $30. The agency did everything it was supposed to do legally. Okay, they provided the response, they generated the responsive records, and so forth. All right, it's not their fault that the person couldn't show up within 2 months to pick up their records. And like I said, the person still owes the $30. But let's say that they still want the records. So they have to submit a second right to know request, and chances are there's going to be another $30 charge, because the agency has to go back and generate the same records again, the same copies. However, the agency doesn't have to do anything with the second request until the original $30 is paid up, until those fees, those outstanding fees are taken care of. Let's assume that the requester no longer wants the original records, but they submit a right to know request for a completely different set of records. Same factors exist. The agency does not have to process any further right to know requests until that original debt is settled, until all outstanding fees are taken care of. But if you're on the agency side of the equation, you want to make sure that all your I's are dotted and your T's are crossed as far as what took place with the original transaction. Okay, you need copies of everything. Have it memorialized as to all conversations that took place, et cetera, et cetera. Because if you deny a request for non-payment of a previous request, it is a denial, and that can be appealed. And that, because you bear the burden, you make your case to the appeals officer. Well, this person owes us money. Here's how we calculated the fees. Here's the communications that we had back and forth. And here's why we denied the second request. If everything's in order, there's a very good chance the appeals officer will support your denial, okay? And you can, again, you can go into our database and read these decisions. Just don't make any assumptions that might be incorrect, and just make sure all your paperwork is in order. Okay, and then finally, I want to say that as far as collections activity goes, if there are outstanding fees, right to know law doesn't address that. So, however you collect fees, however municipality collects fees for, other unsettled debts, maybe that will work out for right to know law. Right to know law simply doesn't address that. Okay, I've said this a couple times, but let me emphasize it because I find it's really helpful when dealing with either very complex requests or very large requests. I should mention, in addition to overseeing training, I'm also the open records officer for the Office of Open Records. Okay, 1,200 requests last year, and we're on track for that again this year. Several times we received very large requests for case files that law firms want, or former appellants want, et cetera, et cetera. Sometimes we just need extra time, or there's going to be some fees involved. So it's not unusual for me to reach out and have a conversation with the requester. Can we have more time, or can we narrow the request? Can you explain a little further as to what exactly you're looking for here? All right, it's quite common. And usually, I'm going to say in 99% of the cases, that conversation is productive, okay? It results in more time, or it results in narrowing the scope of the request, et cetera, okay? Communication is good. There's nothing in the right to know law that prevents an agency from reaching out to a requester, or a requester calling an agency to gain information to help them file the request, or help them see that the request is processed appropriately. So agencies, if there's any doubt, pick up the phone, call the requester. Requester, if there's any questions, call the agency and they can talk to you, okay? Requesters can also specify a cost limit. We just recently issued a decision where the requester had specified a limit. If it's going to cost more than this, please call me first. And the agency failed to do that, and they sent out an invoice above that limit. And we said, sorry, but the request was specific in including this limit. So we are, supporting the requester's specification here. That's not a good word, but you know what I mean. Okay, so the other thing I recommend is that whenever possible, kind of the scenario I used before, the agency should provide an estimate to the requester to make sure they're on board with it. All right, again, no surprises. All right. And then while the agency cannot compel a requester to tell you why they are filing a right to know request, the law doesn't say you can't ask. And sometimes that conversation can be very useful to narrow the scope of a right to know request. Look at this from both sides. If you're a requester, you've got a problem, and in order to solve that problem, you need a record. Maybe you're not exactly sure what that record is, or the form number or whatever. So you write your request by casting a very broad net, okay, to get a bunch of records, and you're hoping that the one you need is in there someplace in the response. But if you're looking at this from the agency side, you want the exact opposite. You want a very narrow cast, because that's going to save you time and paperwork, and you're a busy person, okay? You've got other stuff to do. So in order for, to find the happy medium between these two extremes, what I recommend is, from the agency perspective, pick up the phone, say, look, we got your request. I'm not sure you realize how much this is going to cost you, how many records we're talking about here. Do you mind telling me why you're filing this request? So maybe we can kind of narrow things and save you some money and save me some time. Okay, everybody's on the same page, oh, saving, that's good. And the requester says, well, I'm having this issue with the IRS with my business. They say I need this form in order to take advantage of this particular deduction or whatever. I'm told the township should have it, and the arrow is there. Oh, I know exactly what you're talking about. This happens all the time. I can have that form for you this afternoon. Okay. Obviously, a very win-win scenario that I'm using here, but it's not unusual for that to happen. So it's the result of a conversation that takes place where it gets everybody on the same page, saves everybody a lot of time and money. Yes, communication is good, so please talk to each other. Okay, we get questions about certified records. Oh, and I haven't seen any questions popped up, so I must be doing a really good job here. But like I said earlier, if you have any questions, type them in, and we'll deal with it as we're going along here. We do get questions about certified records. The right to know law allows a requester to say, and this is usually is the result of some sort of litigation that's taking place. And in order to submit these records to a court, there needs to be a certification provided. So the right to know law under Section 1307C allows the requester to say, I want these records certified, and it allows agencies then to charge a $5 fee for the certified records, for the certification. The certification is nothing more than a statement by the agency that says we are going to, or we are certifying that these copies we are providing you are true and correct versions of the original records, that they have not been altered in any way. Okay, as a guest is requesting control. What the heck are you doing that for? I don't know why, but I'm not giving you control of this webinar. Okay, I got off topic here. It's kind of entertaining. Back to certifications. So the certification is nothing more that these are true and correct copies. You are not certifying the provenance of the records in any way, kind of like with law enforcement and chain of custody, like you have to do. You're not certifying that the record, whatever the content of the record, is accurate. You're simply saying that the record itself is, or the copies that you're providing are true and correct versions of the originals. Okay. And usually what happens is legally, this is what we call the records are self-authenticating, or the copies are self-authenticating. If you need sample language, go to our website. We have an Arrow guidebook under the form section, and we've got a template in there for a certification. You're more than welcome to use that. That's why we put it out there. Okay. Another area that we get questions on occasionally are transcripts. Okay. This is a little confusing, so bear with me here. This usually involves adjudication where we've got like a zoning hearing board and someone is requesting a variance, or occasionally, what do we got here? From Janine, if the document on file is already a copy, then the certification cannot be completed. Is that correct? That's a great question. I would go ahead with the certification and put something to the effect that it is a true and correct copy of what we have available, of the original that we have. If you want to get into the fact that the record that you have is not an original, but rather is a copy, yeah, I would probably specify that, since the person is probably requesting it for court purposes. Simply say that this is a true and correct copy of the copy that we have. It is not a true and correct copy of the original. Janine, I realize it's a day after Fosnock Day, but I would give yourself an extra donut if you have one, because I've never encountered that question before. That's a good one. Okay, let me talk about transcripts. Okay, zoning hearing board. There's an adjudicatory hearing of some sort where let me stop stammering here. During the hearing, usually there is a stenographer present in order to take a verbatim dictation of what is said, what is presented during the hearing. Okay, and the result of that stenography is usually a transcript. The transcript is accessible under the right to know law only if two conditions exist. First, all appeals for that hearing must have been exhausted. And, sometimes these disputes can be appealed all the way up to the Pennsylvania Supreme Court, so it can take a while. All right, so that's the first condition. All appeals have been exhausted. Then the second condition is that the agency must in fact have a copy of the transcript. They may pay the transcriptionist like an hourly rate, but they're not paying for the transcript itself because they have no legal need for it. So if all appeals have been exhausted and the agency has in fact purchased a copy of the transcript, then it is a public record and you can request a copy through the right to know law and the fee schedule applies. If either of these conditions have not been met, then you have to go to the transcriptionist and pay whatever the transcriptionist charges outside of the right to know law. And that is usually several dollars a page, much more than a quarter a page. So that's how that works. Those two conditions need to be met. Okay, question has popped up. Let me make sure I didn't miss any here. Yeah, if a requester has an outstanding right to know debt, once they pay, is the timeline for the response the same as the original request, the 5 business days? Does this only apply to outstanding right to know debts or any debts of the municipality? Okay, last question first, only right to know debts. And only within that agency, okay? If they owe money to like the adjoining township, it doesn't apply to you, okay? So only right to know debts. As far as the timeline goes, I would say that the timeline is frozen until the debt is paid. Now, don't take that as any sort of legal opinion because I'm not aware of any final determinations that we've issued that are on point. And this is, again, another original question here. I don't know what you people are doing to me today, but that's a good one. I would say for our purposes, though, just looking at what is fair, if you're denying it based on non-payment and then the person turns around and pays it, I would say the clock starts, you can do one of two things. You can require a new right to know request, or you can resurrect the existing right to know request where the clock stopped based on your denial because the person has now paid. Handle it, come up with a mutually acceptable timeline for resurrecting the right to know request or requiring a new one. I think you could do either way. Okay, from Sue, if the agency doesn't have a copy and the transcriptionist is the person that has the original, can the request be denied? Yes, but I would recommend in your denial where you say you don't have the copy, I would say that you could get a copy from the stenographer or the transcriptionist who was present. As a helpful piece of information for the requester to let them know where they can get a copy of the transcript. They're not going to be happy about it, but that's the reality of the situation. Okay. So that pretty much covers it for the presentation on the payment side. What we didn't talk about are what we'll call problem requesters. Without going into great detail, I'll just say that if your municipality is dealing with a person who is submitting right to know requests, not because they legitimately want the records, but rather because Somewhere along the line, the relationship has broken down and they've weaponized the right to know law just to be a pain in the neck. Take a look at what we've talked about here this morning. And here's what I'm going to say. Usually, most people are more than happy to pay a nominal fee to get public records. The person who is misusing the right to know law is not typically willing to pay any fees. So if by looking at what we've talked about here this morning, you suddenly realize, oh, we should be charging fees to this person, that usually solves your problem. At least that's been my experience with this. And when we, get those phone calls or emails, hey, we've got this person, what can we do here to make them go away? The first thing I ask is, do they owe you any money? All right, go back and think about what we've talked about today, connect the dots, and hopefully you'll have the tools now to deal with those folks. Fortunately, there's not a lot of them. Most people, the greater majority of people filing right to know requests are doing it for legitimate reasons, legitimate business cases. Okay, I want to recommend that you take a look at our website for additional resources. I mentioned a couple of those resources, looking at our final determinations database. Take a look at the Citizens Guide. We routinely send that out to people when they send us questions. We've got that Agency Open Records Officer Guide on there, 78 pages. That's just a wealth of information that agency open records officers can use. Any training resources that you might be interested in, like the PowerPoints, recordings, and so forth, all that information is available on our website. If you're a real geek about government transparency, you can subscribe to our Twitter feed, where every morning at 7 o'clock, we'll wake you up with a tweet about all the day's information, decisions that have been issued, recent court cases, training opportunities, and the like. Finally, if you have any further questions, feel free to reach out to our office, and we're more than happy to, we can't write requests for you. We can't write responses for agencies. I can't predict how an appeals officer is going to rule, but we can try and steer you in the right direction for cases where the facts have been very similar to what you're facing. And, we'll try and get things sorted out for you. So thank you for your participation this morning. And thank you, Karina. And we'll hope to see you at the next webinar. Okay, take care, folks, and enjoy the nice weather. Signing off.